Hello and welcome to Making Sense of ADA, IDEA, and Section 504. My name is Ann Wilson. I'm on the staff of Peak Parent Center. I'm also the parent of a student with an IEP, and I'll be your presenter today. This presentation will be in three sections. First will be the federal laws for students with disabilities. The second part will be an overview of the IEP. And the third part will go into advocacy in the IEP process and dispute resolution options under IDEA. The federal laws that I'll talk about today, and this is in the order in which they were enacted, are Section 504 of the Rehabilitation Act of 1973. Next was the Education for All Handicapped Children Act of 1975, which is a predecessor to the current law, the Individuals with Disabilities Education Act, which was last reauthorized in 2004. And in 1990, the Americans with Disabilities Act passed. I have some introductory notes before I get into more detail. Just want to make sure you keep this in mind. IDEA is an education law that relates to the education of eligible students through the age of 21. So IDEA only applies in the area of education, and it only lasts until age 21. IDEA is the federal law, and so it sets the floor for what states must do. So states may pass state legislation that goes beyond what IDEA requires. They can go beyond, they can't do less. ADA and Section 504 are broader civil rights laws, so they go beyond education and they last through the lifespan. Section 504 applies to entities that receive federal funds, and the ADA applies to most entities in the country, although it has exemptions for religious organizations and private clubs. In 2022, the U.S. Department of Education announced its intent to amend its regulations implementing Section 504. They did take stakeholder comments, but they have not issued their proposed rules or proposed regulations. So be aware that what I talk about today may change. This presentation focuses on students from pre-K to age 21 under Part B of IDEA. IDEA Part C applies to children birth to age 3. And when you go beyond graduation, which could be K-12, or if students stay longer under IDEA through age 21. But beyond that, if you're looking for accommodations in post-secondary education, you'll be looking at 504 and ADA. Peak Parent Center is a training and information center and does not provide legal services or advice. This presentation is for information purposes only. If you have a legal question, we recommend that you consult with an attorney. So the Individuals with Disabilities Education Act is a federal education law. Part B covers school-age children ages 3 to 21 and the students must be eligible. And that means they have at least one of 13 categories of disability. There's an additional category for developmental delay for ages 3 through 9. So you may hear people talk about 14 categories of disability. And they must also need specialized support and instruction to benefit from education. IDEA provides an individualized education program, or an IEP, that's developed by a team of individuals, including key school staff and the child's parents, and that IEP must be individualized to meet the student's unique needs. Section 504 is a federal civil rights law that prohibits discrimination on the basis of disability by any program or activity, including schools, that receives federal financial assistance. It protects any individual with a disability who has a physical or mental impairment that substantially limits one or more major life activity, or has a record of such impairment, or is regarded as having an impairment. A covered organization must provide accommodations to remove discriminatory barriers. And in K-12 education, that will be a 504 plan that removes barriers to learning and opportunities. The Americans with Disabilities Act is also a federal civil rights law, but it goes beyond those receiving federal funding. It prohibits discrimination on the basis of disability in employment, transportation, public accommodations, communications, and access to state and local government programs and services. It has basically the same definition. It protects any individual with a disability who has a physical or mental impairment that substantially limits one or more major life activity, or has a record of such impairment, or is regarded as having an impairment. Note that the individual must be qualified for a relevant program, service, or job. So those ADA protections apply to private schools other than private religious schools, religious entities, or entities controlled by religious organizations are exempt from Title III of the ADA. In the employment sector, ADA requires reasonable accommodations for eligible individuals with a disability to perform essential functions of the job. So accommodations must be reasonable, and the employer determines what the essential functions of the job, and if the person can meet those functions and they're hired for the job, they must be given reasonable accommodations, but they don't have to change the job to make it work for the person. ADA also applies to child care centers and recreation programs other than religious programs. This diagram is just kind of to show you how you have all the students within the schools. You may have students with disabilities who don't need a 504 plan. Then within that, you will have students who are eligible for a 504 plan. And the smallest group is those IDE eligible students. Because again, as I'll talk about, they need to be in one of those categories of disabilities, and they need that specialized instruction. So who's protected under IDEA Part B? It is children ages 3 to 21 who are determined by a multidisciplinary team, including the parents, to be eligible within one or more of the specific disability categories and who need special education and related services. 504 and ADA apply to a person who has a physical or mental impairment that substantially limits one or more major life activity. And those major life activities include a lot of things. Some examples are walking, seeing, hearing, speaking, breathing, learning, working, caring for oneself, and performing manual tasks. And again, under the ADA, the individual must be qualified for the relevant program, service, or job. What do these laws provide? IDEA provides federal financial assistance to state and local education agencies. A local education agency is usually the school district. Sometimes they have other names, but it's that administrative unit for the public schools. So that they can guarantee special education and related services to eligible children with disabilities through the age of 21. And remember that students who have IEPs under IDEA also have rights under 504 and ADA. So Section 504 is a broad law that provides civil rights protection in programs receiving federal funding. The U.S. Department of Education regulations govern the K-12 setting, but there are other regulations for other areas. One important area for individuals with disabilities is the Department of Health and Human Service regulations for things such as hospitals, healthcare centers, mental health care centers that are receiving federal funding. The ADA, again, is the broad law that provides civil rights protections in many areas of life, including in the private sector. In the K-12 setting, and again, I say K-12 setting, but we're talking about through age 21 for students with IEPs. So IDEA is for eligible students through ages 3 to 21. A student may graduate after 12th grade, but some students may stay in the transition program through 21. Under 504, students will not have an IEP, but they will have a 504 plan. These laws provide a free, appropriate public education. This standard is much more developed under IDEA. This has been developed through case law. There's a two-pronged test that there's been compliance with the procedural requirements of IDEA. IDEA has a lot of details about what districts must do. And so things like meeting the deadlines and following the specific procedures. And then there's the substantive standard that the IEP is reasonably calculated to enable the child to receive educational benefit. And the two major Supreme Court U.S. Supreme Court cases on this are Rowley and Andrew F. 504 still provides a free appropriate public education, but in this context, the appropriate education means an education comparable to that provided to students without disabilities. IDEA has detailed procedural safeguards that are designed to protect the rights of the parents and their child with a disability. And IDEA also provides some specific dispute resolution options, which I'll talk about in Section 3. The Department of Education regulations also require school districts to establish procedural safeguards for Section 504. They need to include notice, an opportunity for parents to review relevant records, an impartial hearing, representation by counsel, and a review procedure. In general, families have fewer rights and there's less detail. The regulations do say that complying with IDEA's procedural requirements satisfies Section 504. So that's one way that districts can show they have met the procedural requirements, but they don't have to do that. That's just an option to be clear that it shows. After K-12, I just want to highlight this again, that in education, after you're done with IDEA, it's over. If you need accommodations in higher education, you're going to need that under 504 or ADA. And in the workplace, at 504, requires non-discrimination in organizations that receive federal financial assistance. And the ADA applies to employers with 15 or more employees. So there is that size threshold for ADA to apply. Again, the IEP plan, the IEP is more detailed than a 504 plan. And so this is just to give some of the key differences. This is not every difference, but just to give you an idea, IEP is geared toward progress. So IDEA requires a written individualized education program that describes the special education and related services to meet the student's unique needs. The IEP will have measurable annual goals, and progress must be monitored and reported. The IEP needs to provide educational benefit. Placement is in the least restrictive environment, often called the LRE, and the school district must have a continuum of alternative placements. The IEP must be updated at least annually, and the student must be reevaluated at least every 3 years. So the 504 plan, on the other hand, is much less specific. A plan is required. The regulations don't specifically require that the plan be written, but usually it will be written because otherwise it's very hard to tell that the plan exists and what it provides. The plan's developed to ensure that the student receives accommodations that provide access to the learning environment. Goals aren't required. Progress isn't required to be monitored. I mean, they'll just be, whatever's done in the classroom. Placement is usually in the general education classroom, and annual update is not specifically required. As I mentioned, IDEA has detailed procedural safeguards. This is just to highlight some of the key rights to be aware of. A lot of times parents don't really think about these safeguards until they have an issue. So it's good to be aware of what's in there. One of those rights is to receive a complete explanation of all the procedural safeguards. And that is great. You'll get this handout at every meeting. And the problem with the complete explanation is it's long, it has a lot of information, and it can be a lot to process and take in. But it's helpful to at least look at the headings and know what all those rights are, and when those situations apply, and also be aware that there are a lot of resources to get more information or to get help understanding those safeguards. Parents also have the right to confidentiality and the right to inspect and review the educational records of their child. Parents have the right to participate in meetings related to the identification, evaluation, and placement of their child and the provision of FAPE to their child. So you might hear people talk about meaningful participation of parents. So parents have the right to meaningful participation in these meetings. They also have the right to obtain an independent educational evaluation or an IEE. And in certain circumstances, that can be at the public expense. So a family can choose to get one, and the IEP team will need to consider it. If the family disagrees with the school's evaluation, they can request an IEE, but they have to have had the school evaluation first and disagree with it in order to have that at public expense. And then the school has an option to provide that or to file for due process. The parents have the right to receive prior written notice or PWN on matters relating to the identification, evaluation, or placement of the child and the provision of FAPE. And if the school denies, if you ask for something and the school denies that, they should give you prior written notice or a PWN of that as well. There's a section in the IEP for prior written notice. So if you have a discussion of something in the meeting and the school denies that, you want to record that in the prior written notice section of the IEP. Parents have the right to give or deny consent in certain circumstances, and those are set forth in the procedural safeguards. Some key times are the consent to the evaluation and the consent to the initial provision of special education services. Parents have the right to disagree with decisions made by the school system, and they have the right to use the IDEA mechanisms for resolving disputes. Again, I'll talk about those in section 3. So that's a quick overview of these 3 federal laws. If you have questions, please contact a parent advisor at Peak Parent Center. The number is here, 719-531-9400, or you can email to parentadvisor@peakparent.org.